Sakeliga has sent the Property Practitioners Regulatory Authority, the PPRA, a final letter of demand to provide a written undertaking to withdraw and reverse its BEE policy. Our letter follows reports in recent days that the PPRA has given assurances of a hold on its unlawful BEE policy for the time being. Under the unlawful policy, the PPRA has since at least April this year been refusing to issue property practitioners with Fidelity Fund Certificates, FFCs, based on their BEE status. However, the PPRA has now confirmed to Sakeliga that it has not altered its official stance, offering only the claim that its board is expected to deliberate on the matter. It neglects to provide any explicit undertaking to either suspend or withdraw the policy, and conspicuously, the PPRA also continues to ignore our demands that it should publicly withdraw the policy, communicate its decision to the industry, immediately reopen applications for those who have been denied an FFC and are thereby banned from trading, and undertake not to enforce any similar BEE policy. FFCs are significant because the state prohibits estate agents, developers, management agents, auctioneers, and 8 other industry categories deemed property practitioners from doing business without an FFC or else face prosecution. While Sakeliga would welcome it if the PPRA were to cease its unlawful conduct, it would be imprudent to rely on statements which the PPRA is not itself willing to give or confirm. In fact, the PPRA's continued refusal to provide the necessary undertakings to Sakeliga's legal team, despite having been informed of our intention to litigate, must for now be taken as indicative of an intention within the PPRA to maintain its policy, to find less glaringly unlawful ways of applying it, and to defend it in court. Sakeliga's position remains that the demand for a BEE certificate or an affidavit, regardless of the BEE level of the applicant, is a crucial juncture for the industry, since this demand seeks to normalize unacceptable political interference. BEE has nothing to do with a candidate's suitability to receive an FFC and be a property practitioner, and it should therefore not be entertained as a requirement for FFCs. The requirement of a BEE certificate or an affidavit represents a Trojan horse by which the state is introducing political licensing for economic participation. Sakeliga recommends that business people demand a minimum threshold for credible and meaningful undertakings by state entities like the PPRA. And for undertakings to meet such a threshold, they would at least have to be in writing, explicit, given by the state entity itself, made public, and not be reversible on a whim. We have therefore today informed the PPRA that we persist with our final letter of demand of 2 August 2024, which entails that the PPRA must, in writing, 1. Provide Sakeliga with all its policies regarding the matter. 2. Confirm whether or not it has withdrawn its rule or its policy, whatever, regarding valid or alternatively minimum level 8 BEE certificates for issuing FFCs. 3. Communicate to all property practitioners that they are no longer required to meet a minimum level 8 BEE certificate threshold. 4. Communicate to all who have previously been refused an FFC due to this rule or policy that they may apply immediately based on previously submitted documentation, and that the PPRA will not require a minimum level 8 BEE certificate threshold. And 5. Undertake not to enforce any further rule or policy imposing minimum BEE thresholds or any similar race-based requirements for issuing FFCs. We have notified the PPRA that should it fail to comply with this demand, we will proceed with further legal action, and this will include, among other things, an application for judicial review of the PPRA's decision, over and above any further constitutional or other challenges regarding the validity and constitutionality of the Property Practitioners Act. What's happening now at the PPRA is common among state entities set up to control economic sectors. They set BEE level requirements rolled out in a two-phased approach. First, by introducing BEE certificates as requirements without demanding any specific level of compliance, but then second, by demanding higher and higher BEE levels once an industry has become accustomed to the BEE certification process. Raising BEE to this level of licensing for economic participation is the key feature of the third wave of BEE. For more on these three waves of BEE and why they are so harmful, visit our website.